Good afternoon, everyone. Welcome to today's legal update in the COVID-19 world. I'm so glad we got the volume, the audio working, because I'm good at trades, but I'm not great at trades, and it would have been a long afternoon for me to take you through this presentation by charades or Pictionary. So we do want to welcome you. I will tell you, this is a webinar on the Zoom platform. We do check Zoom's performance before we get on. We do know they're experiencing on their platform some challenges this afternoon. So if we freeze up or you have trouble, we will reboot and get going again. So I just wanted to give you fair warning if that happens. My name is Craig Vaughan. I'm the president of Castle Management. For those of you who don't know Castle, we manage HOAs, condominiums, and apartments in the states of Florida and Texas through 7 offices and approximately 1,700 team members now. Firstly, though, before we get going, I wanted to thank you for your leadership. Most of the participants we will have on today will be board members or committee members serving their community. And we certainly, I'm certain that when you signed up, you had no idea you were signing up to be a leader in this particular circumstance. So the fact that you're front and center, we just wanted to say thank you for your leadership. Thank you also for investing your time this afternoon and your thirst for information about what is available out there, what's going on, how do you better lead your community. So thank you for that. We've got a bunch of questions that you submitted prior to this webinar, and I've tried to incorporate those into our presentation points for David and I, and we will go through a bunch of them. We have some time for questions at the end. Submit your questions online if you like. We'll get to as many of those specifically as we can. Before I ask David to introduce himself, I just wanted to let you know that this is a conversation between David and I. We're going to incorporate some best practices from Castle standpoint. You may not be using those best practices. You may be relying on your professionals that you talk to. Similarly, David's going to give you some guidance from what he would do, but this does not constitute legal advice for you or your association. We strongly encourage you to work out. If you have any questions or follow up to reach out to your particular professionals. So with that, David, can I ask you to introduce yourself and a little bit about your firm? Oh my gosh. David.
I represent roughly about 300 associations across the state of Florida, primarily in Brough, Dade, and Palm Beach counties. And I'm also a board certified condominium homeowner association attorney.
David, thank you very much. We missed a bit of that, I think, at the beginning. I won't ask you to go through again. I know David and I go way back. We've grown up, me on the management side, David on the legal side. So you are well versed in this topic, and we certainly appreciate that. What I want to just quickly run through is the agenda this afternoon. We are going to first review the rules. David's going to take us through kind of the rules of the game at this point in time, and we'll do that. Then we have some additional discussion topics. We're going to talk about meetings. We're going to talk about liability and insurance. We're going to talk about guest and visitor policies, sales and leasing. Collections was a big topic that you asked us to address today. We're going to talk about cash, reserves, and loans, and specifically what may or may not be available to associations under the CARES Act. And then finally, we're just going to address what's next as we hopefully come down the curve here. So let's get right into the discussion. David, we're faced with executive orders. We have county orders. We've got municipal orders. Can you give us an overview of kind of the current state of the restrictions out there?
Sure, Craig. You have to understand, and all participants should understand, that the governor's orders are basically a baseline, and county and municipal orders can exceed those, and they have been doing that. The primary order from the government was the March 9th, 2020 order, which declared a state of emergency. For us as practitioners and for building management and for board members, the most important fact that the government declared a state of emergency enacted, therefore, the statutory emergency powers we'll talk about later. Now, the current county orders have been rolling in place from Broward County, Palm Beach, and Dade. First off, obviously shutting gyms, then shutting pools and requiring social distancing. The latest municipal orders refer to masks. Now, it's interesting that in some of these municipal orders, for example, Fort Lauderdale and Hollywood, it requires that you wear a mask when entering an essential business. Now, by virtue of the county orders, essential businesses include property management. Believe it or not, it also includes attorneys and also accountants and landscaping. So in the world of property management and condominium homeowner associations, while these restrictions are in place, it's pretty much business as usual, as much as possible, practicing social distancing and masks. Now, for a lot of people, how does the latest municipal orders affect you? For example, in Hollywood and Fort Lauderdale, you would be required to wear a mask when visiting the property manager's office. Now, for example, in Western and some other Dade County municipalities, that is not the case. It's just simply encouraged. But I encourage everyone to have a look at these local municipal orders, and even obviously, frankly, as a personal safety measure, even if it just strongly encourage that you wear a mask to an essential business, that you do so for the life of this crisis.
David, I think that's a great point. And your first point was the orders that have been sent out are basically a baseline. You can always do more, right? That's the whole thing.
That's
so
correct, yes.
and I think that's great guidance for associations. The reality is the virus passes by human interaction. So to the extent you can minimize human interaction, that's kind of what I think everybody's looking for. But it is a moving landscape for certain. So I think everyone should heed your guidance to, check with, you know what's going on in your county, your municipality, your city. David, we know that 718, 719, and 720 provide some emergency powers to the board. Can you outline those for us and maybe comment on whether or not there are certain limitations? So, some associations, boards think they can do this, but really the emergency powers don't allow that. So could you talk about that for a couple of minutes?
Yeah, sure, Craig. Well, really the problem with the emergency powers in 718 and 719 and 720 for homeowners associations, that is 720, 316. For condominiums, it's 718, 1265. And the cooperative is somewhere in 719. We don't handle too many cooperatives either. The real problem with these powers was they weren't addressed for a pandemic. Obviously, the disasters we normally get in Florida are hurricanes. And in fact, when these state of emergency was enacted, there was some discussion amongst practitioners such as myself and also with Craig as to whether this did apply under these circumstances. Now, the Department of Business and Professional Regulation did issue an executive order which simply just ignored language in the statute which talks about in response to damage and said ignore that. So all these powers do apply to condominium and homeowner associations and cooperatives. Now, as Craig alluded to it, we're kind of in uncharted territory here because these emergency powers really are in response to hurricane damage or some other earthquake or what have you. So what happens in these, there really are some parts which are ignored. The first baseline we have to look at is these powers are only in place until the state of emergency is terminated. Currently, the governor's order, which was March 9th, expires on May 8th after 60 days. No one knows if that's going to be extended. It's highly possible that it may not be extended based on past experience to the rest of the state. And in fact, it may just apply to the Tri-County area after that date. So any of these powers and limitations we talk about are only going to be good currently through May 8th. So some of the limitations we should be aware of is it doesn't discuss reserves. So there's no power to take money from reserves unless there's some statutory power or power in your bylaws already. It doesn't discuss speaking at board meetings. So while 718 and 720 give a right to speak at board meetings, and this allows the association to conduct board meetings via Zoom or teleconference, regretfully, by virtue of the statute, it still requires, you still have to have the ability to speak, but we'll talk about those later. So really, and looking at it a bigger picture as well too, again, remember this is uncharted territory. It was designed for hurricanes or some other catastrophic damage. So some of the language here really refers clearly to damage, and you need to talk with your Pacific attorney about whether you can apply those provisions of the statute. And we'll be talking about those later with respect to, say, move in and move out powers and the ability to close certain portions of the common area. again, we are in uncharted territory here, and some boards are pushing the limit, and I do respect that with the current state of the crisis. But bear in mind that there's always somebody looking out for you, and if you have to point to a statutory authority here, some of these authorities aren't entirely clear in 718. Craig, should I discuss various portions of the statute?
I think maybe just a general overview. We're gonna.
Sure.
You brought up meetings. I think a pivot into meetings is good, but maybe just a quick overview, maybe to get the landscape set.
Sure. Well, actually, there's various portions here which are applicable. It allows you to discuss board meetings via the internet, i.e. by Zoom or teleconference. It allows you to cancel and reschedule any association meeting. These are the ones which become a bit tricky here. Based upon the advice of emergency management officials and the price of licensed professionals, close off portions of common area and restrict access. Based on the advice of management professionals, determine when to open, and also the authority to borrow money as well too. So they're the big talking points there. But again, all of these only apply until the state of emergency. When it ends, that's it.
Well, I think that's an excellent background, because I know there are boards out there wondering, did I do the right thing by shutting stuff down? Can I borrow money? Can I open amenities? When should I do it? So those are all very relevant points, and we're going to touch on a number of those. Let's start with meetings, because you did say there is some guidance on meetings, and then there are some limitations on that guidance. You know, our amenities are closed. We're practicing social distancing. You know, we're setting up a number of meetings for the board, but what are you guiding? What advice are you giving to your clients and maybe our participants around? And let's start with board meetings. Should you have them? We have to conduct business. Should we? How should we? And how do we address the fact that owners need to be able to participate, as you said?
Okay, well, let's first and foremost, the statute and no bylaws require you to have board meetings at a certain time. And frankly, if you don't have to have a board meeting, don't have it right now. But if you do have to have a board meeting, there are a couple of options. First off, you can make actions by unanimous written consent, which would avoid a board meeting. So that avoids the having to go for the Zoom or the teleconferencing or what have you. But if you feel the need to have a board meeting, you can certainly do this on Zoom. Now, I've done Zoom several times now, I'm sure Craig has. It really isn't designed for large associations. It's my understanding that you can have an application which allows you to give like a virtual hands up if you want to ask a question. But the reality, of course, is not going to work with 500 people. As I mentioned before, the limitation essentially is in the statute that you have to, if somebody challenges on this, you have to allow them the right to speak. And Zoom and a teleconference isn't a viable option for 500 unit associations right now. Again, if you don't have to have a board meeting, don't do it. If you have essential functions that you're going to do, you should be doing those by unanimous written consent.
David, two follow-up questions to that I think are interesting. Number one, the Zoom, we have a Q&A function, chat function on our Zoom setup. Would that be sufficient to allow a resident to talk? Would that be fair if they could Zoom in their kind of chat in their question? You got any idea on that?
Well, it depends what you mean by chat, Craig, because the statute talks the right to speak at board meetings. So if it allows people to speak, you've abided by the statute. What we're doing here today, while obviously it's sufficient by putting in questions via written questions, doesn't technically satisfy the statute. You know, that's the problem. It just talks, the statute says specifically the right to speak on agenda items at board meetings. So speak to me means verbal.
That's good. That's good guidance. And David, on the unanimous consent front, I want to adopt a resolution. I can email it to the other board members and have everybody email their consent. Like, what constitutes, you know, the kind of written consent for a resolution, unanimous consent for a resolution?
Okay, well, the statute, both for condos and HOAs, forbids voting by email. So my recommendation would be, rather than just saying, I agree to this, which technically would be a violation of the statute, is that your attorney should draft up a specific form that recognise that as a resolution, and the following board members on such and such a date, adopted by unanimous written consent, PDF it to each particular board member and have them sign it. and that would satisfy the statute.
That's fantastic. Okay, that's great. That is great guidance. I do see a question about the about liability for board members, and one of the things I didn't mention earlier is there is some protection for board members as volunteers, which we'll get to, and it's the business judgment rule, which I don't want to talk about now, but let's get to that shortly. Let me just touch on the meeting topic. Annual meetings. Some documents which say they have to be held this particular date. Can you comment on annual meetings and the requirement to have them? And then similarly, if you're in the middle of an election, your condo, you're in the middle of your 60 days, do you stop? Do you start over later? Can you give us some of your thoughts in that regard?
Okay, both good questions. First, if you are having, as a HOA, obviously most of them have simply a 14-day meeting. Now, some of the bylaws do require a specific date and time in a month, or it can be as otherwise determined by the board. So regardless if it has that or not, the Emergency Powers Act allows you to cancel and reschedule, and would allow you to cancel and reschedule an annual meeting. And clearly, you would be ludicrous for you to hold an annual meeting at this particular time. So you may choose to send out an email blast to the owners and mention the statute that the annual meeting scheduled for May, assuming we're in the state of crisis, and probably likely will be, we reschedule later date. Clearly, the existing board members would remain in power until that date. Now, a bit more tricky is the condominium. If you've sent out, many of my clients have already sent out a first notice for 60 days, and the date has fallen in April or May, or even late March. In those circumstances, what you would do is those candidates who have timely submitted their notice of intent to 45 days would be on a ballot at a later date board meeting on the second notice after the crisis is lifted. And again, the existing board would stay in power for that period of time.
That's excellent, David. I think that's kind of that's exactly what we're seeing. Postponing as many meetings as you can, and then really talking it through with your attorney, I think is really good guidance, because there are anomalies in everybody's documents. There are things that some associations do that are a little bit different than what you would normally see by way of example in an HOA in 720. So I think, talking the issue through with your particular advisor, understanding their, your particular circumstances is probably a good idea.
Yes.
Let's move on, if we can, to liability and insurance, something I know that's on many directors' minds. We talked about the fact that directors are volunteers, and they don't have to be experts in a particular topic. I mentioned recently the concept of reasonable business judgment. Can you tell me, I'm a board member, how does that work, and how do I protect myself, and what's the rule?
Well, let's apply it to the circumstances as it stands right now. The business judgment rule basically says that as a corporate officer in a not-for-profit corporation, that as long as you rely on the advice of professionals and you reasonably rely on the advice of professionals, you're protected for the decisions you make. Obviously, some of those decisions may be right or wrong. That's in any corporation. So under the particular circumstances today, essentially what you would rely on and how you would act during the COVID-19 crisis would rely on your attorneys, your property manager, your accountant, but most specifically, county and municipal and state orders. Obviously, frankly, if you opened your pool right now or your gym in violation of a county order and somebody got infected, there may be some liability on the board members. So you should be looking at those particular municipal orders, consulting with your council, consulting with management about what you do on those specific cases. Now, bear in mind, the exception for the business judgment rule is very clear in Florida, because if they didn't have a strong business judgment rule, no one would sit on the board. So unless you're dipping your hand and stealing assessments, or you're giving your brother-in-law Jim a contract, you're going to be protected under the business judgment rule. And in fact, a lot of articles in corporation do provide specific indemnification for board members whilst in the course of their duties. And that's why all associations will have directors and officers insurance. So if somebody's threatening to sue you guys, board members, I mean, my partner Zion, Craig, see this all the time, that you are, again, unless you're doing something dodgy, you're protected. So act on the advice of professionals. Don't be scared about making some hard decisions as long as they're upon the advice of professionals. I know that a lot of people got some flack about closing pools early. I know they got some flack about closing gyms early. I mean, that's not something somebody's likely to be you're getting sued over. But if you're specifically relying on advice of a county order, or if your advice of an attorney or a property management company, you are protected.
I think it's interesting. One of the things that board members have to deal with is all of the emotion of shutting down the amenities. I want to use the gym. I want to use the pool. And they've weathered that storm to a large extent. And we're supported by, all the executive orders. We're about, ideally, and touch wood, come out on the other side of this. And we're going to have, I think, board members need to be prepared for the vocal minority again. Why isn't my pool open? Why isn't my tennis court open? Why aren't we doing our social events? So as a fair warning to the board members out there, the emotion, you're halfway through all of the emotional outbursts from your community. You're probably not all the way through it. David, you touched on insurance, and I would definitely include as another expert in this, in your tool belt, so to speak, is your insurance agent in this particular circumstance.
Correct. Yes.
D&O insurance isn't going to protect you from getting sued, but it could rescue you from having to defend that lawsuit and provide some coverage. Can you just comment a little bit about D&O coverage and what protections does it provide the board?
Well, generally, look, frankly, if you get sued for acting within the scope of your duties, and if you're not, again, stealing money or doing something else dodgy, you'll be provided a insurance appointed attorney to defend you, along with the association. We do see a lot of these suits out there, and Craig sees them as well too. In every group of people, you're going to have some people who are very unhappy about the decisions you make, and they threaten to sue you. I mean, the reality is all it takes is word processor, a computer, and $300 filing fee to sue somebody. So, and I know people get concerned about it, but that's why you have directors and officers insurance, and that's why you're protected by the business judgment rule. And again, when we're going out of this, right now, I don't think you folks are copping too much flack right now, but I'm sure as we go out of this crisis, there's going to be a lot of pressure to open the pools. And even though the county may say that you have a right to open the pool, you may still choose to have restrictions there. For example, before this, we went into the crisis, and Craig knows this, various pools limited the number of people there. They limited the number of chairs. They also practiced social distancing. So just a unanimous order from Broward County or your municipality that you could open the pool doesn't necessarily mean that the association can't have certain restrictions in place. The pool should be opened, but you can go over and above that. As long as you're being reasonable, the court looks at reasonableness of your rules.
I think that's great. We're going to talk a little bit about reopening amenities, which wasn't a discussion we could have a month ago. So it's nice that we're starting to hopefully, start to think about that concept. David, I want to move on to another question about guests and visitors. It's been an interesting time when we first started to get some awareness about COVID-19. We couldn't meet in groups of 50, and then it was in groups of 10, and now you can't get within 6 feet of people because we're social distancing and we're locking ourselves down in the whole stay at home program. What can you talk to us generally about what authority does the board have to limit guests and visitors?
Well, right now it's based on 718 and 720, the emergency powers statute. But again, I think that was intended simply to restrict certain portions, the common areas which were damaged by hurricanes. Now, we have to understand there is a difference between condos and HOAs. Obviously, the potential impact of living in a condominium, pushing buttons and getting in elevators are significantly more problematic than a HOA and somebody driving in. Many of my clients have restricted social guests coming into the condominium, and I think that is consistent with the statute. If that was a HOA in the same language as there, that may be more problematic. They're driving to somebody's house. Many of my clients in condominiums have restricted certain business operations or contractors coming in, not ongoing ones, but say, for example, to service your AC unit. And I think that's consistent with the statute. Again, it would be a different story if, for example, a contractor was driving into a homeowner association. You've got to bear in mind there are two levels of risks with HOAs and condos. As to tenants, should we touch on that, Craig?
You know what, we have a whole discussion coming up on tenants and sales and leasing and stuff. So what I wanted to continue on, if I could, in this particular section is,
Okay.
you know, we have seen differences in HOAs and condos. You know, we have, you know, the big HOA that has the guard gate, they have specific procedures in place for their attendance, and similarly, if you're in a condo and valet, kind of what we've seen, the default seems to be to regulating non-essential guests. So contractors is a question we get a lot. You know, can I have a contractor come into my condo? Maybe that's different than having a contractor come into your, you know, landscaping, by way of example, or a project at home. There is a question in this, I assure you, but I guess, what are your thoughts on the concept of non-essential personnel? So family is a big one we hear about, maybe not essential to healthcare, nannies, housekeepers. Can you just let us know what you think about that?
Sure. Again, I differentiate between a condo and HOA. I think it would be certainly, and it becomes a matter of reasonableness. We don't know, we're really much in uncharted territory here, Craig. I don't know how courts would rule on this. I would say there's clearly, as we both agree, there's a separate standard for HOAs and condos. Now, the question becomes is, I think it's reasonable to restrict social guests, somebody who foolishly wants to come over to my place to have a dinner party on Friday night, from coming into the condo. The next level is, could you restrict immediate family to coming to see you? I don't really have an answer for that because the courts haven't ruled on that. Mm-hmm. It's possible. Again, it turns a matter of reasonableness. I think it's borderline. It's very much a gray area. I know some of my clients are restricting immediate families. I know that they're certainly in condos, restricting all social guests. They're certainly restricting housekeepers and other, you know, non-essential people. So regretfully, all of us will have to learn how to clean our own toilets for time being in condos.
That's awesome. Now let's talk about a emotional subject from some of our participants, and that is the whole concept of sales and leasing. Should we be doing them? Should we be allowing move-ins and move-outs? You know, what restrictions can we put on a lease expires? Can I not allow a new tenant in? So loaded question. David, can you start at the top? You know, what should we be doing from a sales and leasing standpoint?
Okay. I mean, again, this is really uncharted territory, and there's been a lot of buzz flying around the practitioners in my field about what to do about this. I think there's a consensus that if there is an existing sale or lease, that you would have to honor that. However, I don't think there's unreasonable that you could restrict the number of the times people could move in, that the amount of movers, the number of movers could be restricted, and they could certainly have required to wear face masks. Now, the more thorny question becomes is whether to deny future leases or sales if somebody wants to get in there. That could be problematic. I mean, you'd have to rest your legal hat on the ability of the association, the right to close off certain portions of the common area. And I simply don't have an answer how a court would rule on that. I mean, you always have to bear in mind that if somebody has signed a lease and it has been approved by the association, certainly you have to go with that. If they submit an application for a lease now, your reason for denial. Now, Broward County and Miami require that you, for a sale or lease, that you give a reason with specificity within 45 days of the application. I think Craig knows that, but a lot of people don't know that. It's one of the few counties in Florida, two counties, that have ordinance addressed as condominiums regarding sales and leases. The reason for denial you would have to give is that health and safety for COVID-19. Whether that would stand up to legal scrutiny, I'm not entirely sure. You would certainly be required to give that type of notice if you're planning on denying them, but also bear in mind there might be a higher standard in that many association governing documents in sales and leasing, within 30 days, the application is deemed approved. Mm-hmm. So again, I come back to the difference between condos and HOAs. In a condo or HOA, I think you'd have much more basis reasonably to deny a new sale or a new lease. And I'm saying that with some caveats. Sure. Then say, for example, a HOA, when somebody just drives in there with a moving van. I think if you're looking at one that you have the most chance and most substance for legal denial would be short-term leases. Mm-hmm. So say, for example, somebody wanted to lease their unit for 2 or 3 months and the condominium documents allowed you to do that. I think you would have much more chance passing the reasonable standard for a 3-month period, given the fact that we'll be falling within the crisis.
Right.
Now, bear in mind, if you do deny these sales or leases, there is a potential for damages for the association as well too. Presumably, if you deny that sale or lease and your denial is based on the COVID-19 crisis and a court deemed that as being insufficient, and I don't know how, there's going to be a lot of litigation about this afterwards, I can assure you. Not this particular issue, but the whole COVID-19 crisis. We don't know how a court would rule. And if the court ruled against you, the association would be liable for damages associated with that denial. And that's something you should seek advice from your counsel about. Unfortunately, the advice he's probably going to give you, like I'm telling you right now, is it's uncharted territory. That's all I can tell you.
Yeah, I think
the risk for denial.
Yeah, great points. I think that it's interesting. You know, you close a pool early and someone sues you, they really haven't suffered any damages, so it's difficult to justify that lawsuit. If you stop someone from renting their unit, they have real damages, real money damages. So it sounds like a slippery slope to me. I can tell you what we found. We have found across the 70 condo towers we manage varying levels of authority on this or practice. I think what we also have found, buildings that are allowing, people to move in, people are very respectful of the circumstance. So, they're setting us up, they're telling us when they're coming in, we're properly scheduling them to the extent they're allowing them, they're using the freight elevator, we have cleaning protocols, for when they're coming in and when they're not. So what we have found in the communities that we manage is, and we're going to talk a little bit about notification later, but it's just humanity stepping up to do the right thing in most cases. So that's a tough question. I know lots of people had questions about it. The answer was it's a slippery slope, and negotiate.
It's uncharted territory, Craig. It's uncharted territory, and I just want to make another point too as well. And Craig, I think you alluded to this. The issue about denying somebody access to the pool and their damages are what's called speculative. If somebody is denied for a sale and lease, they have actual damages, which can be proven in court. So that's something that all clients should be concerned about, all associations.
Right. David, let's move on to collections, another hot topic from our participants and from the first set of questions. And, April maintenance fees were due April 1. Most association documents provided some type of grace period for payment. I would say in our world, a lot of those expired on April 15th. So here we are on the 21st, I think, today. I will say from Castle's standpoint, we ran our global AR balances across all the associations we managed on April 15th, and we compared that to January 15th, and there was virtually no difference, a less than 1% increase in maintenance, which was great news. The association needs their money. We're going to talk about that to operate. But, it was early in the process. It was people hadn't necessarily been furloughed and lost their jobs. The employment problem came after. We see a potentially bigger problem coming for those associations who collect monthly maintenance with May. But at this point in time, we're in a good spot. What is your position with respect to collections at this point? I got to tell you, from Castle's standpoint, we're recommending to our clients, it's a business as usual from a collection standpoint. Of course, understanding that some owners in the community will be more impacted than others, and so maybe have some flexibility. But David, let me get your take on what your thoughts are with respect to collections at this time.
Yeah, we actually drafted an email for our clients basically saying that, and it's their choice whether to send it out to try and get out in front of the curve, so to speak, that the reality is, condominium homeowner associations are not for profit and their sole stream of revenue is assessments. And the board has a fiduciary duty to maintain the common elements in association or common areas in a homeowner association. And how do you do that? You pay vendors, and vendors need to be paid by it. And how do they pay it? Through assessments. So I'm afraid it does have to be business as usual, but with the recognition of some compassion here. Certainly, the association has the ability, by and large, to waive late charges. And a lot of the documents actually allow the association to determine the frequency and time of their assessments. But we don't encourage you to do that simply because that would require you to adjust your budget. If you got, and frankly, it would be ludicrous if you chose just to waive May's assessment, which would then require a new budget. You're still going to have to come out with the same amount of money down the track because the same vendors would need to be paid. So I think there will be a collection problem. I concur with Craig. I haven't seen much of an increase in work, but I would anticipate the May, June for the monthly assessments, and then quarterly in July, there's going to be a significant increase. Associations can certainly handle those at the management level by drafting a payment plan. You should talk to your attorneys about doing that. And if people don't comply, they get sent to the attorney. Obviously, you want to recognize and compassion with 22 million Americans out of work. On the other hand, you do have a business to run. And regretfully, like it or not, board members do have a fiduciary duty to collect those assessments to maintain the common area. And that's something that can't be waived. You could be subject to some criticism. I'm sure Craig will mention this as well too. During the 2008 global financial crisis, and I recognize this probably is significantly more severe, it was essentially business as usual, correct, Craig?
Mm-hmm. Mm-hmm. It really was. It didn't mean that all the money was paid, but we had to work around that. We're going to talk about some of the implications of people not paying. But before we get there, David, I think your guidance on, don't waive a month of maintenance is a good one. Continue to send late letters. The guidance that we are hearing is, don't do a blanket. We're not going to waive the late fees for everybody because that encourages people, of course, not to necessarily pay. With respect to hardships, how do you propose a board deal with that? Do they require some type of notification from a lender, from an owner, excuse me? I like your idea of a payment plan strategy, so it's the same for everybody, but how do you make sure everybody's treated fairly?
Well, there's always an issue in condominiums and homeowner associations, a legal theory called selective enforcement. A lot of times people throw that out and actually has no merit. Now, obviously these need to be done as a case-by-case basis. I've been talking to a lot of my clients. There's no legal obligation or requirement that you get documentation in each case. As long as you're consistent, you may wish to get, say, for example, an unemployment claim record. Certainly, you cannot ask, has somebody been affected by the virus, unless they choose to volunteer that. It's simply a case-by-case basis, as long as you are consistent. And frankly, even during the time period of the global financial crisis, the payment plans which are offered by both, council's end and by the associations never really exceeded 6 to 12 months. Beyond that type of time, it's getting unmanageable. Mm-hmm. And presumably the economy will be back on track after that period of time as well too.
Excuse me, yeah. I think that's, David, the other thing I would say is it's sometimes easier to pay your association. There's no, excuse me, there's no, there's no product or there's no facility out there to help an association from a financial standpoint. We'll talk about that in a second. There are mortgage forbearance rules in place, I know, where if you really have a problem, pay your $300 maintenance fee, don't pay your mortgage, because there's a program out there for people to not pay their mortgage. I know this is a bit of a curveball for you. I didn't ask you about this earlier, but can you comment on that?
Yeah, sure. The state of Florida, there is an emergency order issued by the governor, which has, first off, delayed court proceedings, but has delayed foreclosures for, I believe, 60 days. Now, that only reflected to mortgage foreclosures. So that means that while you have a bit of a break with your, perhaps your lender, that won't stop. I'm not saying the association will do it. The association foreclosing and potentially going to sale on the property or filing a lien or what have you. Now, I think a lot of people learned some, unfortunately, hard and lessons during the time of the global financial crisis. Many questions I had was that you can't foreclose on me, but we can. The association can foreclose on the existing lien, and right now we are exempted from any type of forbearance or what have you. And that's why I would encourage anyone is facing financial difficulties to contact their association and just don't ignore it. Things can happen and the process will continue if you don't reach out to the association.
I think that's great advice. I would also say, I think what we're seeing is keep the process going. It doesn't mean you have to foreclose. There's lots of stuff going on, and there's a moral dilemma on kicking someone out of their home at this point in time, given what's going on in the world. But keep the process going, collect your maintenance, and be prepared, for down the road when we get to the other side. The discussion about collections and accounts receivable flows nicely into a discussion I want to have about, kind of cash reserves. What can I do? What are, from a cash flow standpoint, from a board, what are my options to manage through these situations? I happen to be a CPA, so I talk the treasurer language, if you will. And what I would say to all treasurers is, take a deep breath. Do an inventory of where you are as an association. What do you have operating surplus? A common rule in our world is that associations typically would maintain between 1 to 3 months of operating expenses in their cash account. What do you have? Do you have enough money to weather the storm for a couple of months to see, where this goes? If you're on the low end of that curve, what other options do you have? Do you have reserves? Can I utilize them? And I would start with that one, David, from a reserve standpoint. I'm tight on my operating cash. I have 1 month. I'm now in my second month. I know I have a bunch of reserves. Can I borrow them? And should I borrow? Should I take them, borrow them? And what rules do I have to follow to get there?
Well, you can never really borrow reserves because you're just simply taking them because it's, but unfortunately, the Emergency Power Act doesn't recognize hasn't any discussion about reserves. So a condo to take reserves or to waive reserves would require a membership vote, a majority vote of the membership. Now, that may apply in a HOA's case, but if your reserves were enacted before July 1, 2017, there is a very decent chance you're not governed by the statute, which requires you to seek a membership vote to modify or waive reserves. So if you're HOA, you might have a better chance of using those reserves. But certainly for a condo, you can't borrow them. No.
Yeah, well, I think it's great. The fact that the board received no guidance or extra rights under the emergency powers to use those reserve funds.
Yes.
I think every association, the HOAs especially, there is some confusion around the topic of HOA reserves and when they were initiated and what ability you have to use them and what vote you need. So I think on this one, the advice is, talk to your professionals, talk to your attorney to get some guidance. I will say though, it is an option. And in the face of needing the cash and your options maybe being limited to a special assessment or something else, sometimes your community may be more amenable to allowing you to use those reserves for something they weren't otherwise set up for. We do have a couple.
Can I just add one other thing too, Craig? It's
Yeah.
just coming back to the July 1, 2017 reserves. If you need the money and you believe that your reserves likely were established before that date, and a lot of homeowner associations reserves were, I would seek an opinion from your council and your accountant who could validate that as to the date the reserves were established. Right. And there is a possibility that you may be able to simply reduce those reserves during the time period of this crisis.
Well, that was my next question, which was, we're getting some boards saying, listen, my reserves are pretty well funded. What if I waive the funding of reserves for the next 90 days? Is that a budget amendment? Can I do that as a board? Can you help us on that question?
Yeah, sure. Just to clarify, the date for the reserves is July 1, 2007, not 2017, just to clarify that. Yes, if you can, you would need advice from your council with respect to modifying those reserves if you can do that. And also you need advice from your accountant if you can do that as well too over this period of time. You need to get a legal opinion letter on that.
I think our understanding is perhaps it really is, if they're in the budget, you have to maybe adopt the new budget, but I think it's a good idea to get your guidance from your attorney.
Yes. Yeah.
David, so now I've used my operating funds. I don't have any reserves. I'm worried about the financial health of the association. I maybe already have a line of credit. Should I borrow all that? Should I take all that money, or should I just be comfortable that I have this kind of cash flow insurance out there?
Well, it depends on your circumstance. It's always a case-by-case basis. The statutory emergency powers, both the condo and HOA, do allow you to borrow money regardless of any prohibition in the governing documents. So again, if you're looking at borrowing money, you might want to, I mean, no one knows what their circumstance is going to be right now, but currently you would not need the approval of the membership that's required. Now, many bylaws and articles do have restrictions and require a membership vote to borrow money or a line of credit. There is no difference. A line of credit is still encumbering the association's assets, which is its assessments. So either of the two of those, a line of credit or a loan, you may need to get membership approval. Currently, at least until May 8th, you would not need that approval.
Oh, interesting. In fact, we're working with most associations, don't have emergency lines of credit. We're working with a number of our association clients right now to arrange those. We're in the association business. The banks that our clients are using are in the association business. They understand the loan process. You can count on your professionals, Castles, as an example, or your property management company to put a package together and submit it to the bank. David, you could comment that the security is typical in assignment of your assessment right. So
that's correct.
The banks that know this business, they're ready to step up and provide these emergency lines of credit.
Yeah, let me just add something there, Craig, because associations are actually pretty good borrowers, because unlike everyone participating here, they have a guaranteed income stream, which may dip occasionally, but they certainly have a guaranteed income stream. During the global financial crisis, for a period of time there, it was very difficult for associations to get loans. Now we're seeing a lot more of those. And I would encourage you, if you want to get a line of credit, now would be the time to do it, simply because, again, those emergency powers will expire sooner rather than later. The very first question I get from Lenders Council is, does the association need a membership vote? And sometimes the answer is yes, sometimes it's no. But right now, you won't need a vote.
Well, that's I think that is right in line with what we're recommending, because there's no time, like if you're in decent shape now and you don't think you're going to need the money, the best time to borrow money is when you don't need it.
Yes.
We know the lenders are lending, and they're stepping up. The processing is kind of an expedited processing process for these emergency lines of credit, especially in light of the emergency powers. So we are working with a lot of associations that are doing that. When we're asked how much we should borrow, we're saying, look at the 1 to 3 months of operating expense rule. Get it set up so that you get 3 months of operating cash available. You don't have to borrow it. You don't have to write the check. You don't have to borrow the money yet, but get ready to do it. And there is a cost to doing that. And we're looking at it like cash flow insurance. It's kind of like an insurance premium on what might happen on your collection side.
Yeah, that's right, Craig. You never need, you can have the line of credit there. You never may never use it. And a lot of them don't have penalties. And I just want to advise all associations, you should shop around to get the interest rates and to make sure there's a no penalty clause. I've seen some rates vary and penalty clauses there, but the ones I've seen recently have very low interest rates and no penalty clauses. Yeah,
I think that's a great point. And there are, we all know the lenders in our market that are doing loans and are competitive. And then there are some that aren't necessarily doing as many loans and not competitive. So it's a great point. Shop around. There's lots of competition still at this point in time. I do want to comment on one more thing here with respect to the CARES Act. We're getting a lot of questions on what is the stimulus program doing for me as an association. And David, I want to just go through the two types of loans. There's the payroll protection loan, the PPP loan that everybody is hearing about. And our view from what we've been able to garner by talking to attorneys is that at the base level, associations don't qualify as a business eligible for the PPP loan. Can you just comment on that and confirm if we're on the right
Sure. Sure. I would certainly agree with the advice that you received, because frankly, it's called the Payroll Protection Program, and it's designed to protect employees' paychecks. And frankly, most associations have employees through management companies. Now, it's possible that there may be a limited number of associations who would be eligible if they're self-managed and have their own employees. So I'll speak about that, about the eligibility. Basically, how it works is that you are required to spend 75% of the money on that payroll, and the other 25% can go towards, say, for example, utilities and rent. It simply really wasn't designed for an association because small businesses, it's designed between 300 and 500 employees. A large portion of a regular business is their payroll, which is not necessarily the case with an association because you have other vendors you have to satisfy, for example, landscaping, the elevator guy, and also, most and foremost, high insurance rates as well too. So the program really wasn't designed PPP for the association. It's somewhat of a moot point anyway because the funds are currently run out, although we believe they're likely to be extended. I don't know of any associations who've actually applied for it. Certainly, I don't know how the government would look at that. I would imagine they would probably give that an association, even with employees, more of a run over, more of a closer eye on their application than they would a regular small business.
Yeah, I think we've seen a couple of associations want to apply, and it's more of a let's see if we can get through the system because the system isn't set up to lend to associations. I'm not sure that's a great frame, but we are, we're supporting them if they want to do the application. We don't know of any association that has yet been approved, has yet got the money. So it's interesting. The other side of the CARES Act is the economic injury disaster loans, referred to as EIDL loans. They are managed through the SBA program, up to $2 million, 2.75% for 30 years. Associations, by our understanding, are eligible. We do think it's probably a little bit early at this point in time for those applications. They do require you to demonstrate economic loss, and you haven't had it yet if you have been able to collect your maintenance fees. So we see that as a potential tool down the road. We're advocating for emergency lines of credit right now. Do you have a comment on the EIDL loans, David?
Yeah, I think that unlike the PPP, which you don't have to demonstrate any type of economic loss, the EIDL loans you do. And I certainly think it's premature to go for an EIDL loan at this particular time. I think an emergency line of credit would be a better approach.
Do we lose David? I lost your picture, David, but that's okay.
Sorry about that. Looks like I'm low power on my battery.
No problem. David, but we can still hear you, which is the good news. And I'm the eye candy anyway, so.
Well, no one wants to see my bald head for too long.
I want to talk about kind of what's next. We're starting to get questions from our boards. Thankfully that, maybe we're past the tip of the iceberg and we're coming down the other side and, how am I going to, get things open? I will tell you from Castle standpoint, we've drafted a playbook to basically outline how we see things both from a condo and an HOA standpoint coming back online here. Obviously we're all going to be limited by the orders from the government, but what does it look like? We're happy to make that playbook available. You will see at the end of this webinar an email address for Castle, info@castlegroup.com. We'd be happy to send that to you. But David, we're coming out the other side. We hope, we pray. What do you see? What are you recommending with respect to coming back online?
Well, obviously, any association should abide by the county and municipal orders. To do otherwise could invite a lawsuit and potential negligence on behalf of the association. So I would keep an eye on those emergency orders when you can open the pool, when you can open the gym, when the clubhouse can be open. And again, you can reasonably exceed those orders and still limit the number of chairs by the pool. If you think that's reasonable, limit the number of people go in the clubhouse. But certainly you cannot go below what the county is doing, which is open early.
I think our guidance is have a plan. This is going to come back, and that's what we've thought through is what does the plan look like? What are the rules going to be? How are they going to be relaxed? What are they going to be? So we're happy to make our plan available to anybody. If you're interested, and clearly you would customize it to your own community, get your attorney to sign off, and we would move forward. David, I think we have just enough time for one more topic, and it was one that a number of our listeners and participants talked about, and that was with respect to a resident of the community or an owner in my building. I've learned they tested positive for COVID-19. Do I have a duty as an association to advise the residents?
I think it's a health and safety issue, and I think, Craig, that you do. It's very important about how you draft that message. First and foremost, I can't be clear enough that you, and I've got this question many times, well, can you give me the name or the unit? No. Can you allow me the floor this person's on? No, because you know it's going to be a witch hunt to try and locate that person. So what you would do, you would draft up a notice, and I've done that for my clients, and I'm sure anyone's attorney would have that. And there's certain things that you need to let your membership know. One is that there is a case. Secondly, that they cannot disclose the name or the unit number, that they've asked to be quarantined, that they'll be quarantined. Third and finally, that the resident has been asked not to use the trash chutes or otherwise exit the unit. Now, you have to remember that the association's powers are very limited here. The association's powers essentially to advise. You have the association, particularly in a condo or a homeowner association, has no authority to restrict that unit owner to the unit. They could require them to wear a mask outside the unit, but they can't restrict them to be inside the unit itself. So we get this question many times, can they be forced to stay in the unit? No. What you should also give them to the residents is the Florida Department of website information if they have any further questions about this. But the association's powers are limited to essentially advice and some kind of remedial action, like requiring them perhaps to wear a mask outside the unit.
David, we're on the same page. Really, it's all about communication. Managing expectations. There are specific rules lines we don't want to cross, i.e. designating the resident. So from a castle standpoint, you'll be surprised. We have a playbook on what to do. We have kind of letters that we would have you customize and review with your attorney. What we do when we find out about a case, we get the president, we get the attorney, we get the manager on the line, and we kind of adopt a game plan with respect to how we're going to do this. So I would recommend those owners out there, those board members out there, if you haven't had a case, fantastic news. If you hear of one, you need to get on the phone with your attorney and draft those letters and have a plan. David, we're right at the end of our time. I just wanted to, thank you very much for taking the time this afternoon to provide us with your guidance. I just want to do a quick recap, if I can, of the things we talked about. Meetings, you should have them. There are technology tools around to allow you to have them. If you're concerned, but you need to carry on the business of the association, certainly by resolution, work with your attorney and work to get unanimous consent on the particular resolution. From a liability insurance standpoint, great time to talk to your insurance agent, understand what you have. D&O provides some protection for you. We're very excited that you have the reasonable business judgment rule. So in an advertisement for your attorney, if you're talking to your attorney and you're talking to your professionals, you're going a long way to protecting yourself and the association in this circumstance. Visitors and guests, there's different rules, but most associations now are adopting the non-essential limitations on non-essential guests. We have some powers in the emergency orders to be able to limit guests. Collections, business as usual. Cash reserves, look at where you are, take stock of where you are, plan out this to last to the end of the year and the impact it may have on your maintenance. Work with your banking partners and management companies to arrange emergency lines of credit. And then finally, have a plan. Start to think about what it looks like as we come out the other side, and we'll all pray that we do sooner rather than later. But start to think about that now, because hopefully it'll be upon us sooner than we want. Again, David, thank you very much. Any parting words before we sign off?
Well, I just want everyone, please stay healthy and wear your face masks. And my wife's been sewing many of them. So stay healthy. Look, we're always available here for you like Castle. If you have any questions, always just give us a call. I appreciate the opportunity.
Thanks again, David. And everybody who participated, thank you. If you have any questions, don't hesitate to email info@castlegroup.com. I see through the chat that we're going to send out to some of you our kind of blueprint for bringing our amenities back up again. So thank you for your participation. Thank you for what you do. David, thanks a lot, and everyone have a wonderful afternoon.
Thank you, Craig. Everyone stay healthy. Bye-bye.
Bye now.